Those are the 16 suspects arrested by security at different parts of Kampala during the 23rd March to Parliament protest. The accused before Uganda Road Court were last week charged with common nuisance, to which they all pleaded not guilty. They returned to court before Magistrate Sanura Nambozo. Through their legal team, they asked the court to be released on bail after presenting 2 sureties each.
We are going to apply for bail of all the accused persons, paragraph 8 of the 1995 Ugandan Constitution and section 75 and 77.
DSQ. Your Worship, for A1, Dr. Ivan Sembicha. Your Worship, as per the charges.
Let me first look at the document.
I present Mr. Mutabazi Fred. Mr. Mutabazi Fred is 30 years old. He's 30 years old. He's a resident of Local Council 1, Natetes Central.
Such terms as deems fit. And mindful of the economic circumstances, Your Honor, pray for non-cash bail.
Prosecution objected on grounds that the accused lacked substantial sureties and they have not indicated to court their places of abode. Magistrate Sanura Nambozo overruled the prosecution's prayers and granted bail to all the accused.
I'm objecting to the grant of bail. Your Worship, the sureties that have been presented to this court have not informed the court either by themselves or through their lawyers. They understand the duties of the surety. We therefore take it that they don't know their duties as sureties. Your Worship, the applicants, except for F4 and F14, they have not availed this court in this application. They have not availed to this court in this application proof of their places of abode. Your Worship, the places of abode as indicated on their charge sheet was by their word without supporting evidence to prove the same. Since proof of place of abode within the court's jurisdiction is key in their applications. declare that bail is not granted. To all the applicants. So
It's therefore our submission, Your Worship, that the sureties as presented for all the applicants, stroke accused persons, understand their duties. Secondly, Your Worship, they have the power to compel the attendance the applicants in this honorable court whenever this honorable court so requires. That the applicants do not have a place of abode. It's our submission, Your Worship, that the applicants do have a place of abode, and this place of abode has been clearly indicated in the charge sheet, Your Worship. But also, Your Worship, given that the applicants are incarcerated, they cannot be reasonably expected to present copies, their LOC introduction letters, or their national IDs while in incarceration. It's not possible, Your Worship. This honorable court can, however, order that they present those documents on the next sitting.
Court. They specifically stated that the sureties understood the duty of court and committed to the duty on court terms. In that regard, I find that the sureties have understood the duty and the prosecution objection is accordingly overruled. On the second prosecution objection, that the applicants did not present their letters of introduction to court to prove they have a fixed place of abode, with exception for F4 and F14, we all know that introductory letters for places of residence are personal and therefore ought to be given to an individual and not a friend, a family, or any other person for that matter. I as such agree with Counsel Paul Waswa for the defense in their submission that the applicants could not present to court these introductory letters to prove their places of abode because they were in incarceration. Accordingly, the prosecution objection is overruled. Further, I agree with Counsel Kwizera for A9 in his submission in rejoinder while citing the case of retired Colonel Dr. Kizza Besigye versus Uganda, where it was held that bail should not be unwantonly and unjustifiably denied as long as the set terms have been met. From the application made by and on behalf of the applicants, I note that the sureties presented were well identified to court. They understood the duties of a surety to court, on which basis I find that the set terms under the Constitutional Bail Guidelines and the Magistrates Courts Act have been fulfilled. Relating to the instant case, the applicants, having presented substantial sureties to court, who are closely related to them, have authority over them, and can prevail over them and compel them to attend court as and when court requires, I find merit in the application. I allow the application and admit each applicant on bail on the following terms.
Court will resume on 9th September 2024 formation of the case. George Musisi, lawyer of the applicants, wanted the Director of Public Prosecutions to withdraw the charges against all the accused on grounds of their illegalities.
The other, a group of 19 other accused persons who were arrested while exercising their constitutional right to peacefully protest against the corruption in this country. Court was gracious enough to release all of them on a non-cash bail, for which we are grateful. In the first place, these people were not even supposed to be charged because the offense with which they are charged of common nuisance, either disorderly, offenses meant to annoy these people. These people, what they are not, they were lawfully exercising their right, and they are not disputing that. You can't call someone who is doing something which is enjoying and constitutionally guaranteed as being a common nuisance. Common nuisance to who? As we've seen, the state has said in all the files that they are still investigating. The plea and call and request to the Office of the Director of Public Prosecutions, I hope now that they can realize that this charge was unwarranted. These people were in the excess of their rights, and we think that the ODPP should withdraw charges. That is the rightful thing to do. It's the decent and the legal thing to do. There is no evidence on any of the files, save for the statements of the arrested persons and officers saying that they arrested these people protesting. Instead of making an inconvenience to them, some of them are students, of coming to court endless times and clogging courts, which are already backlogged with other cases which should be heard. All these cases should be withdrawn. So the people released today make a total of over 100 who have been released. There is still one, Eliab Musinguzi, who is still appearing in Nakawa Magistrates Court. He was supposed to come today for a production warrant, but was unable to be brought. And one who is still missing, whose whereabouts we are yet to ascertain, largely because police refused us to access our clients when they are at police custody, and they were smuggled into court in late evening hours. So we don't know whether he was granted bail or police bond, but at least we can, as far as we know, he appears on the charge sheet, but he hasn't been seen anywhere. We shall continue to try to see that he's also accounted for. But for now, we at least upload the judiciary for hearing the cries of the Ugandans that these people should not be in custody. Who should be in custody are corruption suspects or people convicted of corruption. Against these people should be withdrawn because they shouldn't have been arrested in the first place. All the arrested persons, all the people granted bail, they still stand by what they said, that they were protesting peacefully. That's a constitutionally guaranteed right. The courts have pronounced themselves on peaceful protests. So they shouldn't have been in jail in the first place. They shouldn't have been charged in the first place. And we think that court, the DPP, should exercise her discretion by withdrawing all these charges. They don't stand the legality test, neither do they stand the public interest test, in whose interest the DPP acts.
Other people who attended the court, including some leaders, had this to say.
Just like any other days, we have come to Buganda Magistrate Court to stand as sureties to our colleagues who were arrested recently during the anti-corruption protests. The batch of colleagues that have been brought today, these are students and some of them are alumni in institutions like Makerere University Business School, Makerere University and Kyambogo, led by the NUP institutions leader, Comrade Musili David, Kamuga Bruno, Dr. Sempija, Ivan, and all that. We appreciate the court that at least they have granted these people bail because it's a constitutional mandate. And even these people, by the time they came up, they are protected under Article 29, Clause 1, subsection D, that says that any Ugandan is privileged or is mandated to come out and protest peacefully, unarmed, against the injustices or against any mismanagement of public funds. But we saw that police arrested these people, detained them, and for over like 2 weeks they have been in jail. We came here to stand as surety, and we are glad that the magistrate has granted them bail. We also demand for other colleagues who were arrested, but up to now they are not presented before the court. Case in point, Shabib Abdul. He was on the charge sheet. Yesterday he didn't appear before court. Even today he didn't appear before court. We are wondering where this person is being detained. So we are beseeching the prosecutor, the state attorney, to present this person before court, because the hours that are legally stipulated in law, whereby the person is supposed to be detained in jail, it is past 48 hours. So we request that this person be brought to court so that he can also get the justice that he deserves, just like his fellow colleagues that have been granted bail.
First and foremost, my name is Makana Kennedy Amachi, and first and foremost, we'd like to thank the judiciary, for upholding the rule of law and granting us bail. Some of us got bail a few days earlier than our brothers who have been released today, most of whom have been released today, and those 2 of them are still held up in prison, and we shall continue demanding for their release. As young people, as the Ugandan Gen Z, we are out to say that corruption is that corruption should be put to an end, and enough is enough. We shall continue hitting the streets since our demands are accomplished. We want accountability for our money, and we are saying the Speaker must resign. The call is still on, and we are not sleeping. And we want to tell Ugandans that do not sleep. This is our money. They are stealing our money. The money that should have worked on roads is being stolen. The money that should have bought drugs in hospitals is being stolen. So we are out here to say enough is enough. We shall continue advocating for it. We shall continue hitting the streets until our demands are fulfilled. We are not fighting the government. We are fighting corruption. We are not fighting the president. We are fighting corrupt leaders. Things must change in this country, and we are going to make sure that they do change. Thank you very much.
The released suspects make a total of over 100 protesters who were arrested during the March to Parliament protest.